Everyone, welcome back to Shruti IAS. This is video 9 of direct sources of each questions asked from Polity, specifically from Lakshmikanth book, which is our main source of preparation. To understand what we're doing here, I suggest you watch the 2005 video. Just the 3-4 minutes of that video and you'll understand what exactly is happening. In a shorter version, we are going to mark all the questions that have been asked in UPSC in the last 20 years. Today, we are going to do it for the 2013 paper. This is a screenshot of my book where I have highlighted the questions, options of questions that have been asked in UPSC Prelims, along with the year in which that particular question was asked. Let's start with the first question for 2013. The topic is National Development Council. The question is, who among the following constitute the National Development Council? Options are Prime Minister, Chairman Finance Commission, Minister of Union Cabinets and Chief Ministers of States. For this, we go to Lakshmikanth, chapter 56, Niti Ayog, page number 472. Under National Development Council, the composition is directly given here. PM, all Union Cabinet Ministers, Chief Ministers and Chief Ministers of Union Territories, and members of Planning Commission, now Niti Ayog. So 2 becomes incorrect. Finance Commission Chairman is not a member of the National Development Council. Coming to question number 2, the topic is Public Accounts Committee. Consider following statements. The Parliamentary Committee on Public Accounts consists of more than 25 members of Lok Sabha, scrutinizes appropriation and financial accounts of the government, examines the report of the CAG. Okay. For this, for first point, we come to chapter number 24, Parliamentary Committees, page number 272. Under Financial Committees, under Public Accounts Committee, it's directly given. At present, it consists of 22 members, 15 from Lok Sabha and 7 from Rajya Sabha. So it cannot be 25 members here. 15 from Lok Sabha is the limit and 7 for Rajya Sabha. 1 becomes an incorrect statement. Same page, in more detail, the functions of the committee are. So same page, left side, 4th paragraph, in more detail, the functions of the committee are. The point number 1, to examine the appropriation accounts and the finance accounts of the union government, which makes the statement 2 as correct. Same page, left side, 2nd paragraph, the functions of the committee is to examine the annual audit reports of the Comptroller and Auditor General of India CAG, which are laid before the Parliament by the President. So 2 and 3 become correct, 1 is an incorrect statement. Coming to question number 3, the topic is ministers. Which of the following principles are implied institutionally in the parliamentary government? Point number 1, members of cabinet are members of parliament. We're not going too deep into this because this is pretty straightforward. Members of cabinet are also the council of ministers, which are the members of parliament. So statement 1 is correct. For statement 2, members hold the office till they enjoy confidence in the parliament. This is Article 75, collective responsibility of ministers. Chapter 21, Central Council of Ministers, page number 215. Under collective responsibility, line 6, they work as a team and swim or sink together. When the Lok Sabha passes a no confidence motion against the Council of Ministers, all the ministers have to resign, including the ministers who are from Rajya Sabha. So statement 2 is also correct. For statement 3, let us first look at chapter 13, Parliamentary System, page number 132. The President is the head of state while Prime Minister is the head of government, right? Second part of this, for the third statement, we go to either chapter 18, President, page 186, or either chapter 20, Prime Minister's, page 208. The President is the head of the Indian state. Chapter 20, the Prime Minister enjoys the The Prime Minister enjoys the following powers as the head of the Union Council of Ministers. So from here we can see that the Prime Minister is the head of Union Council of Ministers. For this particular question, we are going to take Union Council of Ministers and Cabinets as the same thing. As Prime Minister is the head of the Union Council of Ministers vis-a-vis Cabinet, and he is the head of government, not the head of state. President is the head of state. So statement 3 becomes incorrect. 1 and 2 is the answer. To read the differences between Central Council of Ministers and Cabinet, we go to page number 216 in chapter 21. The differences are given here in a table. Coming to question number 4. Consider the following statement. The Council of Ministers in the centre shall be collectively responsible to the Parliament. The Union Ministers shall hold the office during the pleasure of the President of India. The Prime Minister shall communicate to the President about the proposals for legislation. Now here we come to chapter 21, page number 213, Central Council of Ministers, under Article 75, point number 5. The Council of Ministers shall be collectively responsible to the Lok Sabha, not to the Parliament. So statement 1 becomes incorrect. For second point, the Union Minister shall hold office during the pleasure of the President. Same page, point number 4. The Ministers shall hold office during the pleasure of the President. For point number 3, the Prime Minister shall communicate to the President about the proposal of legislation. For this, we come to chapter 20, Prime Minister, page number 209, in relation to the President. The first points are para A. She is the principal channel of communication between the President and the Council of Ministers. It is the duty of the Prime Minister to communicate the President all the decisions of the Council of Ministers relating to the administration of the affairs of the Union and the proposals for legislation. Hence, 2 and 3 become the correct answer. Statement 1 is incorrect. I think in the last question I said that the Council of Ministers is responsible to the Parliament. It's not. It's only responsible to the Lok Sabha. Coming to question number 5. Consider the following statements. National Development Council is an organ of the Planning Commission. For this, we go to chapter number 56, Niti Aayog, page number 472. The NDC was established by an executive resolution on the recommendation of the first 5-year plan. It is neither a constitutional body or a statutory body. While it's not directly given that NDC is not an organ of the Planning Commission, but we can remember this for future references that NDC is not an organ of the Planning Commission. It's an independent body. Point number 2, the economic and social planning is kept in the concurrent list in the Constitution of India. For this, we come to Appendix 2, page number 712. Under concurrent list, entry 20, economic and social planning is given, which makes our second statement as correct. For point number 3, we come to chapter 39, Panchayati Raj, page number 390. The Constitution of India prescribes that Panchayat should be assigned the task of preparation of plans for economic development and social justice. Under powers and functions in Panchayati Raj chapter, page 390, the state legislature may endow the panchayats with such powers and authority as may be necessary to enable them to function as institutions of self-government. Such a scheme may contain provisions for the devolution of powers and responsibilities upon panchayat at the appropriate level with respect to A. So this is our answer. The preparation of plans for economic development and social justice, which makes the third statement as correct. Answer becomes 2 and 3 only. Coming to question number 6, consider the following statement. The chairman and the deputy chairman of the Rajya Sabha are not the members of that house. For first point, we come to chapter 23, Parliament, page number 233, Chairman of Rajya Sabha. The presiding officer of the Rajya Sabha is known as the chairman. The vice president is the ex officio chairman of the Rajya Sabha. The deputy chairman of Rajya Sabha. The deputy chairman is elected by the Rajya Sabha itself from amongst its members. That means this statement becomes incorrect as deputy chairman is elected from Rajya Sabha amongst its members. For statement 2, while the nominated members of the two houses of the parliament have no voting rights in the presidential election, they have the right to vote in the election of the vice president. For this, we come to chapter 18, President, page number 186. We look at the election of president. It's clearly given here the nominated members of both the houses of the parliament, the nominated members of the state legislative assemblies, of the state legislative councils, and the nominated members of the legislative assemblies of Delhi and Puducherry do not participate in the election of the president. For election of vice president, we come to chapter 19, vice president, page number 203. It's clearly given here that the electoral college, it consists of both elected and nominated members in the parliament. And in case the president or elected members. Statement 2 becomes correct, statement 1 is incorrect. Coming to question number 7, topic is Nalsa, chapter 38. Coming to question number 7, the topic is Nalsa with reference to National Legal Services Authority of India. Consider the following statements. Its objective is to provide free and competent legal services to weaker sections of the society on the basis of equal opportunity. It issues guidelines for the state legal services authorities to implement the legal programs and schemes throughout the country. For this, we come to chapter 38, I think lower courts and other courts, page number 374. First paragraph, I think 7th and 8th line, you check here. The Legal Services Authority Act was enacted by the Parliament, which came onto force on 9th November 1995 to establish a nationwide uniform network for providing free and competent legal services to the weaker section of the society on the basis of equal opportunity. Direct statement is given here, which means this is correct. Same page, right side, second paragraph. The NALSA lays down the policies, principal guidelines, and frames effective and economical schemes for state legal services authorities. Statement 2 also becomes correct. Our answer becomes both 1 and 2. Coming to question number 8, the topic is Forest Rights Act 2006. So this is not in Lakshmikanth. This is technically a news or a current affairs questions. But let us still look at the answer. Under the Scheduled Tribes and Other Traditional Forest Dwellers Recognition of Forest Rights Act 2006, who shall be the authority to initiate the process for determining the nature and extent of individual or community forest rights or both? So the answer is Gram Sabha. We study this in our environment notes. Coming to question number 9, preamble and DPSP is the topic. Economic justice is one of the objectives of Indian Constitution, has been provided in. Let's look at the options. So preamble, fundamental rights, or fundamental rights and DPSPs, none of the above, and preamble and directive principles of state policy, right? So for this, we come to chapter number 5, preamble, page number 45, under subsection 6, justice. The term justice in preamble embraces three distinct forms: social, economic, and political. Directly, it's given that economic justice is here. In the next paragraph, the word economic justice has been used, but it's also giving our answer. For the second part of the answer, let us look at chapter 9, DPSPs, page number 109, under socialistic principles, under the classification of directive principles, and under socialistic principles. In that, these principles reflect the ideology of socialism. They lay down the framework for a democratic socialist state aimed to providing social and economic justice and set a path towards welfare state. So our initial 1 or 2 DPSPs like 38 and 39 talk about economic justice, right? Coming to question number 10, the topic is DPSPs. According to the Constitution of India, which of the following are fundamental for the governance of the country? For this, we go to chapter 4, salient features of Constitution of India. Second paragraph, 8th line, directive principles of state policy. Second paragraph, 1, 2, 3, 4, 5, 6, 7, 8th line. Yeah. In India, however, unlike the fundamental rights, the directives are non-justiciable in nature. That is, they are not enforceable by the courts for their violation. Yet the Constitution declares itself that these principles are fundamental in the governance of the country, and it shall be the duty of the state to apply these principles in making the laws. Answer becomes directive principles of state policy. They are fundamental for governance. Sure. Coming to question number 11, the topic is money bills. Let us look at chapter number 23, page number 248, Parliament chapter, under money bills in page number 248. Okay, so the entire process of how a money bill is passed is given here. A money bill is passed by the Lok Sabha. It is transmitted to the Rajya Sabha for its consideration. Rajya Sabha has restricted powers with regards to money bill. It cannot reject or amend the money bill. It can only make recommendations. It must return the bill to Lok Sabha within 14 days with or without recommendations. The Lok Sabha can either accept or reject any of the recommendations of the Rajya Sabha. If the Lok Sabha accepts any recommendations, the bill is then deemed to have been passed by both houses in a modified form. If the Lok Sabha does not accept the recommendation, the bill is then deemed to have passed by both the houses in the original form passed by the Lok Sabha without any change, right? So basically what happens here is B is wrong. This Lok Sabha cannot consider. Of course it can consider the bill. It's directly given here. It's their choice if they want to take the suggestions or not. If you check here in the second paragraph, if the Rajya Sabha does not return the bill to Lok Sabha, the bill is deemed to have been passed. So B becomes incorrect. The Lok Sabha may send the bill to Rajya Sabha for reconsideration. There is no option for reconsideration. Either they accept the recommendations or they don't accept the recommendations. The President may call for joint sitting of passing the bill. There is no option for any form of joint sitting in the case of a money bill. So our answer becomes A. The Lok Sabha may still proceed with the bill, accepting or not accepting the recommendations of the Rajya Sabha, which is given in a second paragraph. Coming to question number 12, which of the following statements are correct? For first statement, in India, the two persons cannot be appointed as governor of two or more states at the same time. For this answer, we go to chapter 30, governor, page number 313. Usually there is a governor for each state, but the 7th Constitutional Amendment Act of 1956 facilitated the appointment of the same person of the governor for two or more states. So this is an incorrect statement because here it is written a person cannot be appointed, right? For point number 2, the judges of High Court of the states in India are appointed by governor of the state, just as the judges of Supreme Court are appointed by the president. Now we know that the judges of High Court are appointed by the president, but let's look at the answer in a book. Chapter number 34, page number 354, High Court chapter. Appointment of judges. The judges of High Court are appointed by the president. Clearly it's given that they are appointed by the president, not by the governor of the state. So B also becomes incorrect. For point number 3, no procedure has been laid down in the constitution for the removal of the governor from his post. Again we come to chapter 30, page number 315, governor chapter, term of governor's office. The constitution does not lay down any grounds upon which the governor may be removed by the president. Now this becomes a correct statement, right? They've asked which is the correct statement here. C becomes the correct statement. For the fourth one, I couldn't directly find it in M.Laxmikanth. In case of a UT having a legislative setup, the chief minister is appointed by the president, not by the lieutenant governor. So the answer, this is also an incorrect statement. Let's remember this for future references. Answer here becomes C. Coming to question number 13, Constituent Assembly. With reference to the Indian history, the members of the Constituent Assembly from the provinces were, right? So we know that the members were from the princely states and the provinces. Let us look at the exact answer for this one. We come to chapter 2, Making of the Constitution, page number 11. Point number 4, under the composition of the Constituent Assembly. Point number 4 gives us the answer. The representations of each community were to be elected by the members that the community in the provincial legislative assembly, right? And the voting was to be done by the method of proportional representation by a means of a single transferable vote. The representation of princely states were to be nominated by the head of princely states. So for provinces, very clearly the members were elected by the provincial legislative assemblies, right? It's written here directly. And for now here it's written directly elected by the people. No, they were elected by the provincial legislative assembly. Nominated by Indian Congress and Muslim Wing, this statement doesn't make sense. Selected by the government for their expertise in constitutional matter doesn't make sense. Our answer becomes C, elected by the provincial legislative assemblies, given here. Coming to question number 14, the topic is amendments. An amendment to the Constitution of India can be initiated by an introduction of a bill in the Lok Sabha only. If such an amendment seeks to make changes in the federal character of the Constitution, the amendment also requires a ratification by all the states of India. Now, anybody who has watched all these tricks and tips videos, usually words like all, every are incorrect. Usually, I mean, it's not very true for recent papers, but for older papers, it was true. Any which ways, let us come and look the answer for this one. We go to chapter 11, Amendment of the Constitution, page number 213. Now, under the procedure for amendment, we check the, just a second. Yeah. Point number 1. An amendment of the Constitution can be initiated only by the introduction of bill for the purpose in either house of the parliament and not in the state legislature. Either house of the parliament, here it's written Lok Sabha only, 1 becomes incorrect. We come to point number 5 for the second statement. If the bill seeks to amend the federal provisions of the Constitution, it must be ratified by legislature of half of the states by the simple majority. So, sure, not all the states, half of the states. So this also becomes an incorrect statement. Answer becomes D, neither 1 or 2. Coming to question number 15, the topic is Attorney General. For this, we come to chapter 53, page number 450, 451. Attorney General of India, rights and limitations. In the performance of his or her official duties, the AG has the right of audience in all courts in the territory of India. Further, he/she has the right to speak and take part in the proceedings of both the houses of the parliament or their joint sitting and any committee of the parliament which he/she may be named a member, but without the right to vote. He/she also enjoys all the privileges and immunities that are available to the members of the parliament. Now we check. The Attorney of the Attorney General of India can take part in the proceedings directly given here. They can take part in the proceedings, right? Yeah. Just a second. Right to speak and take part in the proceedings. So they can speak in Lok Sabha. C is correct. 3 is correct. Take part in the proceedings. 1 is correct. Any joint sitting in any committee. So he can be a member of any committee of Lok Sabha. 2 is also correct. Without the right to vote. So vote in Lok Sabha? No, he does not have the right to vote. So 4 becomes incorrect. Our answer becomes 1, 2 and 3 only. Coming to question number 16, which of the following does not find mention in the Constitution? National Development Council, Planning Commission, Zonal Council. For National Development Council, we go to chapter 56, Niti Ayog, page number 472. National Development Council was established by an executive resolution of the Government of India on the recommendation of the first 5-year plan. Just after this, it was written that just like the Planning Commission, it is not a constitutional body nor a statutory body. So 1 is correct as it does not find the mention in Constitution. Again, similarly for Planning Commission, the Planning Commission was established by by an executive resolution of the Government of India on the recommendation of Advisory Planning Board constituted in 1946. Again, they are not a constitutional body, so Planning Commission is also not in the Constitution. Again, for zonal councils, we go to chapter 16, Interstate Councils, page number 170. The zonal council is statutory and are not constitutional bodies. They are established by an act of the parliament, that is the State Reorganization Act of 1956. Again, they are through an act, not through a constitutional amendment. So C is also correct. So answer becomes D, 1, 2, 3. Coming to question number 17, the parliament can make any law for whole or any part of India for implementing international treaties. Now, for this we come to chapter 15, Center-State Relations, page number 147. Parliamentary legislation in the state field, point number D, to implement international treaties. The parliament can make laws on any matter of the state list for implementing the international treaties, agreements or conventions. The provision enables the central government to fulfill its internal obligations and commitments. Same chapter, page number 165, 253, legislation for giving effect to international agreements. So this is about Article 253. The parliament can make law without the consent of the states. While I couldn't find a statement which directly wrote like that it is happening without the consent of the state, but let us know this for future references, and if anybody else finds it anywhere in the book, they can let me know in the comments. But we know that parliament can do this because it's given as a power under Article 253. So answer is D, without the consent of any state. Coming to question number 18, the government enacted the PESA Act in 1996. Which of the following is not identified at its objective? We come to chapter 39, Panchayati Raj, page number 393. Under the objectives of the PESA Act, for point number A, to provide self-governance, we see the point 2 here, to provide self-rule for the bulk of the population. To recognize traditional rights, for point B, we come to point 4, to evolve a suitable administrative framework consistent with traditional practices. For point number D, to free tribal people from exploitation, we come to point number 5, to safeguard and to preserve the traditions and customs of the tribal communities. So these 3 are given. To create autonomous regions in tribal areas, this is not a part of PESA Act. Our answer becomes C. This one is not identified as an objective of the PESA Act. Now, if you have watched the video till here, I have a small request. We're thinking of starting either modern history or geography PYQs for the last 20 years as a parallel series, because polity questions take a bit of time in finding in Lakshmikant. So please let us know what should we start, because we're getting a lot of comments, but like they're haphazard. So if you can comment under this video and let us know if you would prefer geography questions from 11th and 12th NCRTs to be done first or modern history questions to be done first. Thank you. Have a good day.